the issue again was deeply charged, and birthright was not a unanimous decision, even though the constitutional phrasing is in English. Now, guess what? Clarence Thomas, Supreme Court Justice Clarence Thomas, guess what? He had a dissent with 28,000 words. He's been a man for so long who doesn't say too much. And I love the clap back from Justice Ketanji Brown Jackson. She said what she wrote. Despite this longstanding endorsement of a colorblind constitution, Justice Thomas now surprisingly suggests that the citizenship clause was a race-conscious remedial measure. Oh, well, you know what? I want to get into that with none other than the head of the NAACP Legal Defense Fund, Janae Nelson. And hey, hi, Janae. This is a big day. How are you doing? We can't hear you. Hold on. We can't hear. Okay. Yes. Make sure you're unmuted.
All right, how about this?
I hear you. How you doing? And how was the day for you?
Today was a mixed bag, but all in all, I'm very pleased that a narrow majority, but a majority nonetheless of the Supreme Court did the right thing in recognizing that the 14th Amendment's language is pretty plain and clear and simple. But it is deeply alarming that there are four justices for whom this was even a partial question.
Justice Kavanaugh.
So
Let's talk
the
about
fact
that.
that
Justice Kavanaugh.
Yeah, Justice Kavanaugh issued a concurrence and a dissent, and then we had three justices, Gorsuch, Alito, and Thomas, who issued a dissent. And frankly, this should have been a 9-0 decision. It should have been clear. We did not need, nearly 200 pages of ink spilled on this question, unless it was to just lambast a president for thinking that he could rewrite the Constitution and the 14th Amendment at that.
Hmm.
Um, but here we are. This is the low bar that our Supreme Court is at. And while we celebrate this win, we were very honored to co-counsel this case with the ACLU. We were very honored to defend the 14th Amendment successfully. This was too thin of a margin
Yeah.
for my taste. And I don't think that the Supreme Court deserves any major accolades for reading the Constitution, for its reading comprehension. Okay, that is where I am on this case.
Oh my gosh, for its reading comprehension, I'm thinking about Schoolhouse Rock, just the basic ABCs and one, two, threes. You're on point. Jen from our chat says, yes, Kavanaugh giving Trump a roadmap to try to change the Constitution. What do you think about that?
That's that's right. I will admit I have not even been able to get through the entire decision.
Uh-huh.
But from what I gleaned of where Kavanaugh is, he is in that, state of equivocation, trying to play both sides of this issue. And it was not a a round condemnation of
Yeah.
what Donald Trump was trying to do through an executive order, trying to rewrite the Constitution with a Sharpie. That should have been roundly condemned by all the justices. And Justice Kavanaugh, took a very weak sauce position.
Kavanaugh said, in my view, the executive order does not violate the 14th Amendment, but the order does contravene a federal statute. So at the end of the day, it's a lot, it's a play on words. And as you and Jen just said, now I want to go to something else. There were three decisions today, and and then I want to get into yesterday's decisions as well. The next one, highly sought after decision, but we knew which way it was going to go. The issue of transgender sports, transgenders playing in girls and women's sports. And Kavanaugh again wrote the majority opinion, but added that transgender girls and women who want to play sports deserve respect and should not be ostracized or vilified. But there is now a ban on transgenders playing in women's sports. The Human Rights Commission President Kelly Robinson says of the decision, no kid, not my kid, not your kid, not any kid deserves to be discriminated against. What do you say to this?
I say that this is a very unfortunate decision, that it doesn't reflect reality. We have co-ed teams in many sports. We have kids playing together at early ages. We are able to segment competitors and athletes based on their ability, based on what competition level they are. And we see people as people, right? And that's really how we should be judging folks, and not based on their gender. I think these are very antiquated ways of looking at people. This goes back to the same issues around bathrooms and lockers and just I think a very limited view of how we can create a society that is inclusive for everyone. And this decision, I know, is an extreme disappointment for people who have transgender children, and for all of us who stand as allies with the transgender community. But this is not the last piece of this battle. There are more fronts to fight, and we will continue to support our transgender allies in that fight.
Another issue Donald Trump weighed in on, this time at the White House. Remember, months back, he was fighting with a governor about transgender sports. He said, "Oh, we'll see you in court. We'll see you at the Supreme Court." Again, another issue Donald Trump has weighed in on. He didn't go to the court for this one, but again, it's Donald Trump
He
again.
set the
And
climate. He set the
yes,
climate.
yes, yes. And is that what we want our governments to do? It's one thing to write an amicus brief, a friend of the court brief, but it's another thing to basically start a situation that leads to the Supreme Court. Now let's go to the overturning of campaign finance limits. This favors the Republicans who already have this great chest of money that they're sitting on. Talk to me about that. And it now goes to the political parties, the RNC and the DNC, to handle it. Talk to me about that, and why should we care about that?
Well, we should care about this for a number of reasons. I mean, LDF is a nonpartisan organization. We care about money and politics because money is now driving politics in a way that is almost uncontrollable. And the Supreme Court continues to permit that with very few limitations. And today's decision effectively allows political parties to coordinate with their candidates, which is a way to sort of circumvent the constraints on how much a candidate can raise and how much parties can raise and how much they can pool their resources. And so what we're going to see is an arms race. We already are seeing record-breaking elections and spending in elections that does not really reflect who is most popular among the people. It's who can outspend the other candidate. And that means money is deciding at the ballot box, not people. And we should all be alarmed at this latest way to subvert the will of the people by
Hmm.
making money the king as opposed to people's choice.
Hmm. Wow. Chalk says any win against this administration is a victory. But this one, this campaign finance issue wasn't. AJ says, not enough of a win for birthright citizenship. The court is not okay. There is a consensus that there's something
The
wrong
court
with
is
the
not
court.
okay.
Yeah. Why do you say that? And
Oh yeah, the court is not
you,
okay. The court is not okay at all.
and
Yeah, I
you,
mean, I say this as someone who, yeah, someone who leads an organization that for 86 years has been in a very robust, seemingly intellectual dialogue with the court. We've lost many cases, we've won many cases. We take our lumps, and even if we disagree with the court, we respect the institution. Right now, the court has a composition that appears to be supremely compromised. And they are not bound by any rules of ethics.
yeah.
There are basic constraints that they are not, voluntarily adhering to. And so, as a result of that, at a bare minimum, we need them to be bound by a strict ethical code. And there are other reforms that we should be thinking about and discussing as a society when it comes to this important third part of our government.
Ethics, when we talk about ethics, just yesterday, we saw the video of Clarence Thomas sneaking in or sneaking out of the meeting with the Speaker of the House, Republican Speaker of the House, and we still don't know. There you go. There you go. When you talk about ethics, and there's supposed to be a separation of the branches.
That's
That's
right.
crazy. Yeah. So, and let's get to the part, and I'm going to go to tomorrow, or what happened yesterday, excuse me. But let's get to your part. Like you said, for 86 years, your organization has been in front of the Supreme Court arguing cases. And just this year, you argued on behalf of voting rights in Louisiana versus Calais, a historic day. The first African American woman to sit on the U.S. Supreme Court, and then you, a black woman in that court arguing for both of you basically were on the same side of this, not communicating with each other, but both pretty much on the same side of this. Um, Talk to me about Calais and the ramifications of Calais and yesterday's decision on the victory on mail-in voting in Mississippi.
Yeah, when I was standing before the court, I was asked what would the consequences be if the court were to change Section 2 of the Voting Rights Act. And when I say change, I mean eviscerate, obliterate, effectively make it unenforceable. And I said the repercussions will be catastrophic. And, some tried to paint that as hyperbole. Some tried to say it really won't be that bad. And in fact, Justice Alito, in writing the decision, tried to couch this as an update to the Voting Rights Act. What he did was create a decision that many have called the worst in the past century when it comes to voting rights. And I stand by that because what we saw in the days, frankly, within the hours of the Cali decision being issued, are states stopping elections that were already in play, where voters had already cast ballots in order to gerrymander our congressional districts. We saw states, especially across the South, erase decades of Black power building and leaving large swaths of Black populations across the South with no ability to elect candidates of their choice, candidates who represent their interests. And the South has the largest population of Black people of any region in the country. 60% of
Yeah.
Black people live there. And we have now disenfranchised that population by diluting their votes in congressional districts and often in state legislative districts and other maps where we elect people from districts. We have taken us backwards by about 60 years in some states. Excuse me. And you know, that's the world we are now living in. We are trying to defend against that. We're trying to mobilize communities. The best thing we can do is to turn out and vote in full force, but also to elect people who will enact a new Voting Rights Act and to have state level Voting Rights Acts, which have been introduced in places like Alabama, Mississippi, et cetera.
Yeah.
And that's our next order of business.
It was an honor to sit next to you at that panel, the Juneteenth panel at Union Chapel in Martha's Vineyard. And you said something that will stay with me forever. You said, we don't have to keep clinging to hope in one piece anymore. We can rewrite our new Voting Rights Act because you said now that it's gone, you're sad that it's gone, but now you can rewrite something new. So talk to me, what does that look like?
Yeah, we've been in the business of salvaging. We've been in the business of holding on to shrapnel from a Voting Rights Act that was obliterated in 2013 in a case called Shelby County versus Holder, when the Supreme Court effectively made Section 5 unenforceable. And we've been clinging to every piece that was left of the Voting Rights Act up until now. There are still important provisions. So I want to be really clear. You have Section 203 of the Voting Rights Act, for example, which allows for bilingual assistance and translated ballots, which is really important for people who don't speak English or speak English as a second language. So I'm not saying that there's no value to the existing provisions, but what I'm saying is that the Voting Rights Act no longer serves its intended purpose, which was to ensure that Black people in particular and every other group of color that has experienced voting discrimination in this country has an opportunity to be represented by people they select who will represent their interests and be accountable to them. And so what we need now is a robust Voting Rights Act. We need to pass the John R. Lewis Voting Rights Advancement Act, and we need to expand it and update it to make it fit all of these new um, uh, uh, prohibitions that the Supreme Court has enacted. We need to address all of those. We need to make sure that it stamps out partisan gerrymandering. And we need a very robust anti-voter suppression act as well.
Yeah.
There's so many things that we can be doing to transform our elections, make them more fair, more inclusive, and more free.
Unlike in the 1960s, it's not just the South anymore. A lot of states are participating in
No.
these racist behaviors when it comes to voting. Going back to the chat real quick, Sheila says some people want to stack the court, and I agree. Do we need to be worried about Trump, about that? Worried that Trump might try to do that before we do. Also, yeah, I think about Merrick Garland all the time. I think that was a mistake that should have been corrected. And also, Jay says Frederick Douglass warned President Johnson about the black codes. What do you say to Sheila? Do you think the court should be stacked? Do you think if Democrats win, they should try to expand the court?
Yeah, I don't believe in that terminology of stacking the court. I think that suggests something unfair. That suggests something political. What I do think should be on the table are all reforms that can restore public confidence in the Supreme Court. Among those are potential term limits. Among those are bringing the emergency docket out of the shadows so that these justices can't issue decisions without having briefing, without us knowing what their decision-making process was. And among those also includes expanding potentially our judiciary, certainly at the district court level, also at the appellate court level. And when we get to the Supreme Court, I think that is worthy of conversation. We're not prepared to say that the Supreme Court absolutely should be expanded, but we are certainly going to do additional research and consider this as a possibility because we believe that firmly in the necessity of having a court that people can have faith in. And right now, the public has a crisis of confidence in the Supreme Court.
You just broke news. You just broke news. All right. An organization founded and started by Thurgood Marshall. I mean, gosh, this is great. Now, and the last two, because we only have a few more minutes, and I'm so thankful that you took time today. This is a big day. I know you could have been other places, but thanks for coming here. Um,
Always
so
happy to be with you, April.
Thank you. And we're going to see each other at Essence this weekend for the July 4th, the Essence Festival.
Yes.
It's not just about a party, it's about informing the masses. So you remember that, guys. So also the Supreme Court had a decision on appointees, administration appointees. Could you speak to that? And also Lisa Cook was allowed to stay in her job, but the retaliatory DOJ is still trying to indict her. Isn't that wrong? Something's wrong there.
Well, one of the first things that's wrong is that, again, the Department of Justice needs to be wholly separate and apart from the president and the president's influence and authority. So when we go back to fundamentals and we start refounding this democracy, which is what's going to be required on the other side of this nonsense, we need to have a strict line and a strict wall between the executive branch or the executive office and the Department of Justice. But effectively, listen, we are so thrilled that Lisa Cook gets to continue to challenge her termination, and that the Supreme Court made it clear that her termination is likely invalid. That you can't just rewrite statutes and pretend that for cause means at will, meaning that you can just let go of an employee for any reason at all. No, that's not what. That's not the protection that people like Lisa Cook have on the Board of Governors. And so she, I think, is in really good stead and standing as she continues to pursue this litigation as a governor, as someone whose position has been fully reinstated and endorsed by the Supreme Court. That's number one. We do know, however, that the court issued another decision that does make it easier for the president and anyone who occupies that office to try to get rid of administrative personnel in certain federal agencies. So
Mhm.
the win for Lisa Cook is not one that extends across the board to all federal
Yeah.
agencies. And now we see that a majority of the court is inviting this president to try to rebalance or reposition different federal agencies and potentially uh, populate them with political lackeys. And that would be, again, a horrible expansion of executive powers. So while many are celebrating some of what this court has done this week, I think we need to be really sober-minded about the destruction that it continues to mete out.
Jen says the court is out of touch with the populace and has been ruling with political aims for years now. That is true. I just want to thank you for being here, and this is a big day, and thank you for being able to explain this in layman's terms, because there's a lot of thus, there art, wherefore, there as that people are like, wait a minute.
Yep.
And that's some of the reason people are turned off by getting involved in the process, but the process definitely concerns you. Yeah, we're talking about you. The process definitely concerns you. Anything else you want to add?
I just want to say, gear up and get ready. We got an election ahead of us. They're going to try to throw every obstacle in our way. We need to make sure that we are registered to vote. We need to check that list twice. We need to take this as seriously as possible. We need to vote early. We need to turn out and protect the polls. We need to be poll monitors, poll workers. This is our democracy to save and defend and then to refound to make it serve all of us. That is our charge, and we have to do everything possible to meet this moment.
Meet the moment. I always say that. Janae Nelson, the head of the NAACP Legal Defense Fund, she's out there fighting for you. And this Supreme Court session, she stood in front of the justices and argued down
Thank you.
the validity of keeping the Voting Rights Act, but they changed it. But thank you for your service. Thank you for caring so much to make sure that we are protected and democracy still stands. Thank you, Janae Nelson.
Oh, thank you,
with your
April.
invisible cape.
I appreciate you. All
Thank
right, you take
See you
care.
soon. Take care.
Okay.